covers material turned over by the government to the defendant, correct?
That's correct.
And it provides that such materials shall be used by the defense only for the preparation of a defense and shall not be disclosed to anybody not involved in the preparation of the defense. And of course, it does not apply to anything that that is part of the public court record, anything that is used, for example, in judicial proceedings or introduced in evidence and so on. Should privacy concerns emerge, such materials will be designated before being made public.
Judge, if I may interrupt, and I apologize.
Sure.
But Mr. Edwards just called me. He got thrown off the screen.
Oh my goodness.
Hold on. I have him here. I'm going to mute myself for 1 second.
Sure.
Okay, I see you now.
Yeah, and we can hear you, Mr. Edwards. Can you give me an indication of when we lost you? Were we talking about the confidentiality order, maybe?
Right before that, I guess.
Okay. All right. I enumerated the orders that would be entered.
Yes.
And you heard that. So, and then I went to the protective order. I called it confidentiality order. It's called protective order. And I just summarized that it has essentially to do with materials turned over by the government to the defense. They're being turned over only for the use of the defense and preparing the defense, and not otherwise disclosed. That anybody involved in the preparation of the defense obviously may see it, and that of course it does not apply to anything that is part of the public record. For example, anything that's introduced in evidence and so on, obviously is not subject to the order. If there are privacy interests, for example, bank account numbers or personal identifying information, I'm just giving examples, that will be flagged beforehand before it's released publicly for redaction or other ruling of the court. Mr. Mindy, that was kind of an overview, but was that a fair summary of the order?
Yes, Your Honor. My understanding after speaking with Ms. Fayes is that this is certainly a protective order, but the defense has very broad ability to use anything as we deem fit in the defense with any terms of investigation, discussions with others, etc., for public dissemination.
Right, exactly. And I want to make it clear that, look, this is a criminal trial, it's a public proceeding, and anything used in this proceeding obviously is going to be public, with very few exceptions. However, there are no limits on what the defense may use it for in terms of preparing their defense, and this is really designed essentially to protect certain kinds of private information. I mean, I gave the example of bank account numbers and things like that. Given the financial nature of this case and the wide-ranging case, it seemed best to have this order in place. I do urge the parties not to be overbroad about designating things as confidential, the discovery, what passes between the prosecution and the defense generally is not public unless and until used in the case anyway, but it seemed best to have this in place beforehand, so I will sign that. All right, with that, anything further, counsel?
Nothing for the government, Your Honor.
Nothing for the defense.
Okay, thank you, everyone.
Thank you, Judge. Have a good day.
Thank you.
You
Take
too.
care.